Amongst those half that do, over half make exceptions for bars precisely like Zeno's. What they say is, okay, this is an establishment that where people are consuming liquor. It's an adult-oriented establishment. They only let in people over 21, and it's not a restaurant. They don't really sell food, or they sell a very small amount of food incidentally to their activities. And that those kinds of small liquor permit holding bars should in fact be exempt, because it makes no sense to attempt to regulate them. And if you, as a citizen, want to avoid the effects of secondhand smoke, it's then very easy to do so. You simply don't show up at those kinds of establishments. You frequent other establishments which you enjoy frequenting more because they don't have smoking there. And the owner runs the risk of losing your business and then has a decision to make about whether to allow smoking or not. It becomes a free process where individuals can voluntarily cooperate on societal solutions instead of being forced into cooperation that makes no sense.
Phil, you were talking about the voters have spoken on this issue, but the fact is that there was another issue that was a constitutional amendment. I forget the number on it, but you folks backed the other constitutional issue. And voters turned that down too. They didn't like the idea that you proposed before. So haven't the voters already spoken on this anyway?
Fair question. But let me say that, again, from my perspective, the piece that we drafted was very clear. The other issue is exceptionally unclear now from 2 court decisions I speak. Not my personal opinion. 2 court decisions have said that this thing is a mess. So what did the voters really vote on? Heck, the judge can't even figure it out for the people.
And let me step in as well, because you asked that question, and that's often the argument, is the voters voted for this. Well, it's important to remember that we do not live in a pure democracy. We live in a constitutional republic where there are limitations on what your neighbors can do to you. Your neighbors cannot vote by majority vote to enslave you because it violates our state constitution and our federal constitution. Similarly, the voters can't vote on other things that are unconstitutional because they perhaps deprive you of your property rights or because they give administrative agencies authority that they're not entitled to. And the latter was the case here. So we have the Constitution to safeguard our liberties from the tyranny of the majority, which is in some ways what the smoking ban embodies.
But couldn't you say that about anything that any practice? Say if you're smoking pot in your house, the cops can come in your house, even though that's your personal property, they could still come in your house and cite you for smoking pot because smoking pot is against the law. So if smoking in a public building, a place where the public goes, if you're smoking in there, how do you have a property right to do that when the action itself is against the law? You see what I mean?
I do see what you mean. It's a little bit of a tangent, but I will answer the question anyway. The marijuana is illegal anywhere in the state, no matter whether you use it in your own home, whether you use it on the street, or whether you use it in a business. Smoking is not illegal except on certain types of property that are characterized as public property for the purposes of the smoking ban. That unequal treatment of certain types of property in Ohio renders this a property regulation as opposed to the marijuana regulation, which is a regulation of conduct. Regulation of conduct is a little bit more broadly acceptable constitutionally than regulation of property in Ohio, and that's why this is a property rights issue. I hope that adequately addresses the distinction.
They point out in here that there's a statutory scheme for fines against businesses that violate going up to $5,000. If health departments were to start going after individuals, would they have to follow the same fine schedule, or would the legislature have to come up with fines of its own?
Oh, no, that's an interesting question, because that's exactly the point, James, is that there is already a provision in the statute that requires patrons to be cited when they have been asked or notified of the smoking ban. And that is precisely the provision that the Department of Health and all their local designees have completely ignored up until now. And you can't just pick and choose as a government agency which parts of the statute that you like to enforce, because some parts are easier to enforce than others. You must enforce the entire statute. That section is Revised Code 3794.02 subsection D, and it states that the patrons shall be cited if they've been notified that the ban is in effect. And that's precisely what we're trying to do, is create at least equal enforcement. Now, there's also a fine structure already in place for those individuals. but it doesn't go up to $5,000. It's $100 per citation. And I believe that if an individual is cited again and again, it's still $100 each time for the individual.
Maurice, just to clarify, I thought that you said earlier that the court said that the enforcement of the law was unconstitutional. Doesn't the court actually say that the state overstepped its authority under the act? Did the court ever say anything was unconstitutional?
That's correct, and the decision can be a little bit confusing. I had to read it a few times myself, because what the court does is, I think that it characterizes our property rights arguments as quote-unquote constitutional arguments, and then looks at the health department's conduct as something other than that. However, what is clear is that when an administrative agency exceeds the authority delegated to it by the people or by the legislature, it acts beyond the scope of its constitutional authority and unconstitutionally. So the court does phrase it in a way that is confusing to understand, but its findings are that the agency acted beyond its authority, which is always unconstitutional. And so that's the ultimately why the enforcement methods are unconstitutional. That's why I have used that terminology, and I apologize if that's confusing you in light of the court's decision.
Well, the reason I was asking, you had mentioned earlier about possibly asking the legislature to change the law. If the legislature should change the law so that the Smoke-Free Act language would allow something like this, then it would no longer be unconstitutional?
I think that could be true. It would very much depend upon what the legislature did, but the legislature can grant greater authority to the health department. That's correct. And then the question is, are they entitled to grant that authority? That may raise other issues, but you're right, that could be a solution.
Mr. Craig, is it your expectation that the health department will stop enforcing the law like this right now or tomorrow across the state? They say they're appealing and that things are going to go on the way they have been.
We expect them to cease and desist, but we'll have to see what they do. We are ready to take action if they continue to pursue this illegal persecution of permit holders.
What will your action be?
And I'm prepared to take action beyond just the defense of bar owners, because we do now have a ruling in place that states that it is unconstitutional for a government employee to enforce the law in this manner. What that means is that each health department employee in the state is on notice that their actions are unconstitutional if they go ahead and enforce the ban in this manner. That means that they can be exposed to personal liability over Ohio's government immunity standards if they go ahead and enforce the law and act in this fashion. And we are prepared to monitor each and every instance where that occurs if the state is in fact adamant about continuing to enforce the law as is in violation of this rule.
This isn't the first court to rule on this. The Franklin County Appeals Court basically came to the same conclusion in the poorhouse case out of Toledo. Why is this more significant, or how is this different?
The poorhouse case could be seen as limited to certain factual scenarios. This case very explicitly addresses the health department's policy statewide and in all instances. This case, unlike the poorhouse case, finds that there was in fact a policy that the health department and local health departments have pursued across the state. And then it further finds that this policy, which is universal, has in fact violated Zeno's rights and others' rights. And this creates a much larger class of business owners whose activities are protected from the poorhouse case. The poorhouse case stopped a little bit short of determining, the poorhouse case determined what you have to do as proprietor. And so this judge was correct to rely upon that in reaching the decision it did. But this judge went further and noted that that is all that a proprietor has to do, and where the health department ignores that and issues citations anyway, it's acting beyond its authority.